Beautiful fingers you got there. Good morning. Good morning, Miss Katie.
Good morning. How are you?
Doing wonderful. Did you get wet this morning?
Not yet, but I got a little wet last night when we were walking the dog.
Uh-huh.
Yeah. Yeah, hopefully the rain is moving out soon.
They tell you it moved leaves and everything else out of our ditches and our subdivision, so
I tell you, the wind has been crazy.
maybe it's gonna blow all the coronavirus away or something. I don't know.
Let's hope so. Oh, man. So, is it just you and I right now?
No, there's somebody else there. They don't have a name. They're Pixel 2 XL. They've got their video on. They're hiding up on the ceiling, but I don't know who they are.
Oh, okay. All right then.
Cool. I do the
Yeah.
same thing. Most of the time when I'm on my meetings, I don't do video, just because that way I can pay better attention. No, multitasking something else. So,
Oh, right.
but
Well, you know
sometimes
what?
it's cool to see everybody else too. So,
Yeah, I normally do video, but nobody needs to see me in my bathrobe right now. So
fair enough. I think that this is the new standard. So,
I think it might be. I think what we knew is definitely going to change.
yeah, I guess, and it's okay for the people that were fighting, kicking, and screaming. It's too late. It's changed. The dial tone, the touch tone phone is going to be here. So, all right. Well,
Yeah.
it's 10:02. Let's go ahead and get started here. So let me see if I can figure out how to do this. Share my screen, share, and I'm getting to be the whole cat's meow now. So the post-settlement occupancy is pretty simple. It's 2 pages. I'm just as scared of these as I am pre-settlement occupancy. The problem is that when it works really well and does a great job, but when it blows up, it's really, really bad. Um, and the problem is this is not really a rental agreement or a lease. It's just a temporary right to live there. When you go back to your pre-licensing, you've got the bundle of rights that you give up. One of them is a right of possession, and when you rent a property, you give them a lease and you say, listen, I still own the property. You can't commit waste. You can't sell it. You can't destroy it. It's my property. And you have to abide by the terms of the lease. And part of the lease says I can't come in and knock on your door every day and have possession. So, I know that there is a valid reason for that. I guess I always get to see it when it's not so good. But we can protect everybody the best we can using this post-settlement occupancy agreement. it's in there, our zip form library. The one we use is the NVAR form K 1020, and it's pretty simple. When you go through, you fill it out, put the day of it, and this actually becomes part of the contract. So this is not a separate lease agreement. This agreement is made on April 13th as part of the sales contract offer between Bobby the buyer and Sarah the seller and Sam the seller for the purchase of the property of whatever it is. So what this makes a contract or becomes valid. It says in consideration for the mutual terms of this agreement, because a contract's got to have consideration. It's got to usually have money. But what they're saying is their consideration, they're considering mutual terms of the agreement as part of the consideration. Buyer permits the seller to occupy the property after the time of settlement under the following terms and conditions. This is where we got to get the money right. So number one, it says the occupancy charge. It says seller agrees to pay the occupancy charge as follows. Blank per day, inclusive of both the settlement date and occupancy deadline. So, if they're moving on, if closing's the 1st, they start the 1st. If they're leaving out the 15th, the last day is the 15th. Or a flatter amount. Hey, it's going to be, $200, $300. Sometimes it's just easy to pick a number. Or the buyer gets to choose, including pretty much all of his costs. It says it gives you the math how to do it. He said you take the 12 months of mortgage payments, including principal, interest, taxes, and any mortgage insurance, plus, not limited to, any annualized condominium fees. So if it's done by the month or the quarter, you can do it by the annual. Property owner fees, association fees, property insurance premiums. You divide it by 360, so you get a daily rate, and then you multiply the number of days from settlement to the occupancy deadline. It's pretty simple. Usually what I do is I grab a calendar and start calculating, and literally count them on the thing. Because then I say, okay, well, they're going to move in the 15th, and they're going to move out the 27th. 27th from 15 is how many days? And I just do it on a calendar. To me, it's easier and simpler. And then the bottom line, it says inclusive of both days as calculated by the settlement agent and the settlement agent's sole discretion. They get to pick. If they want to add the property owner fees or not, that's up to them. If they want to add property insurance, it's up to them. But that's the price. The whole idea is that the buyer shouldn't have to be out any money, and that's the biggest thing. So that's who comes up with that number. And then it says the parties agree that the occupancy charge is not rent and it's not a lease, but a temporary right to use, not subject to the Virginia Landlord Tenant Act. So they don't have any rights according to that Landlord Tenant Act. And all statutory provisions of the residential rental laws that are otherwise exempt from Virginia Landlord Tenant Act are hereby waived. This means that the terms of the agreement control and the common law of Virginia applicable to non-residential rentals applies to this agreement. They do have some rights by law, but not covered through the Landlord Tenant Act. And obviously, common law is more broad than the Virginia Landlord Tenant Act. That's what scares me about these. And I mean, it's not skewed for the landlord or the tenant. It's to help both parties understand that. Okay. Then number 2 is the deadline. It says the seller must vacate. You've got to get out and get possession of the property and keys to the buyer on or before 9 p.m. Pick the deadline. That's the deadline that we're referring to in 1. It says if you vacate before the deadline, let's just say if they're waiting to move and the moving truck comes early, you got to check the box. Will they refund any part of the occupancy charge, or will they not refund? Some people say, listen, I've given up 14 days of my house, and if you leave in 3, I still got to pay like motel bill or whatever else, and they don't want to do it. But that's really going to be up to the buyer, and the buyer is the one that's going to really initiate this. Even they're the ones that, it's just like typically when we do a rental, the landlord produces the lease, not the tenants, because the landlord wants to protect their rights. Okay. If vacating before a deadline, seller must give buyer at least 3 days written notice before vacating. Hey, listen, understand that you folks are not responsible for enforcing this document. This is a not you thing. You are not a property management. I know that we just helped our buyers, our sellers, or whoever in this transaction, and we feel the urge to help them. But we have an agency agreement, and our agency agreement says buy them a house or sell them a house. Okay, so be very, very careful. If it gets into to some dispute, you need to say, listen, I don't know much about that, and they need to talk to an attorney. But just stay away from this with giving advice, because this is a not us thing. 2B is default, because if a seller fails to get out, then then they'll pay double the daily occupancy or blank per day. Just pick the number. Same thing too. Sometimes if you come up with a daily occupancy charge, it's $80 a day, or if above, let's just say you charge them $500 for the whole time. Make sure whichever one you're doing. Also, the seller will be responsible for any reasonable expenses as the seller's result of failure to vacate. Temporary accommodations, furniture storage, moving costs, attorney fees. They don't get out, they're gonna have to write a check. So let's just say if you're on the buyer's side and they want 3 or 4 more days, and they say we're not getting out, they're gonna ask you advice. Say, listen, I'm not an attorney, but on 2B, this is what it says. Sounds like you need to talk to an attorney. And I'm not one to always kick it to an attorney, but when seems like there's a lot of people that sign these agreements, but they don't want to abide by them. Okay. 3, property maintenance condition. The seller shall maintain and repair the property. Notice how they're referring to him as the seller, not the tenant. The tenant's got different rights, including electrical, plumbing, existing appliances, heating, air conditioning equipment, fixtures, in substantially the same condition as date of settlement date. When y'all do your walkthrough, you better do a really good walkthrough. On the pre-settlement occupancy, there's a Virginia Realtor Form 1100. It is a great walkthrough sheet to go through. That's when I manage properties, that's the one I use as when they move in and move out. A couple days is probably not going to be a big deal, but let's just say that you do your walkthrough, the house looks good, the guy moves out a week later, then there's a scratch on the wall. If you don't have any documentation, when you do your walkthrough, when you have this, you got to do a walkthrough as a rental. Was that glass broken or was it not? Was the ceiling fan working or was it not? I mean, I think you need to do your due diligence for your client for their walkthrough, and they can use that sheet to do the when they vacate. Okay. Same thing, broom clean it with all trash and debris removed, delivered to buyer, all keys, fobs, codes, and digital keys. Security deposit. You can hold one or not hold one. If you do, remember United, we don't hold escrow. It could be the buyer hold it. Could be their title company, be an attorney, but we don't hold escrow. It says buyer may, without prejudice and other legal rights and remedy, use all or any part of the security deposit to defray any costs incurred because they're non-compliance agreements. So let's just say they give you $1,000 deposit, they're late a day, and they've got to use motel rooms or whatever like this. This right here says they can do that. Buyer must conduct, not may, not should, not a great idea, must conduct a post-occupancy inspection of the property and deliver to seller and escrow agent a list of deficiencies within 3 days after deadline. So after they move out, you've got 3 days to get this done, or waive any claim to security deposit. So if you don't say anything, it's no harm, no foul. So that's what you need to do. At which time the escrow agent may release funds to the seller and will be held harmless by the parties for any future claim. Remember, an escrow agent, all they're doing is they're just writing a check back and forth. When party A and B agree, there you go, or whatever has been performed in this agreement, once they check the boxes, then they're going to give the money. It says escrow agent may require agreement of parties before dispersing the funds. Every escrow company is different, but they might just want to have a form sign off and say buyer and seller agree that the deposit can be released. Utilities will keep all in the seller's name and pay all the costs until the deadline. So remember, the deadline is, when you see some capital like this, we're talking about the deadline which we picked in up here, occupancy deadline. Risk of loss. Any personal property not included in the sale but kept on the property by seller shall be made at seller's risk. Just because the buyer now owns the house, it's the sellers, their stuff. It says seller shall hold buyer harmless for loss or damage to any personal property or bodily injury to any persons having access to the property. Might be their movers. Might be somebody coming to visit them. And shall maintain adequate insurance. Hey, listen, when they sell our house, guess what's over usually when it's over? Homeowners insurance. A lot of people don't think about that. Seller is, like you said, hey, it's no big deal. I closed on the 15th. Oh, somebody got hurt on the 17th. Now it's a problem. Seller is responsible for maintaining insurance to cover the seller's personal property. Might be renter's insurance, if desired during the period of this agreement, until seller vacates the property in accordance with the occupancy deadline paragraph above. Buyer will maintain homeowners insurance adequate to protect buyer's interest in the property after the time of settlement. You need to pass that on to if it's your client that's the seller, you need to say, hey, listen, you need to talk to your insurance agent. Find out what you need here. If everybody moves out, no problem, nothing burns down, we're okay. Something burns down, somebody knocks a hole in the wall, the agent falls through the stairs, or the moving guy falls through the stairs, then it's a problem. And then access. Seller will permit buyer reasonable access. That's my favorite word, is reasonable access. I don't know what that means. I don't know if that's 24-hour notice. I don't know if it's 2-hour notice. I don't think it's come knocking on the door right now. To the property, and will deliver one set of keys to the buyer at settlement. So the buyer now can get into his property. If property is to be offered for rent, let's say the new purchaser is going to rent the home. Buyer or buyer's agent shall have the right to show the property during reasonable hours 30 days before termination of this agreement. This kind of mirrors our lease. So if this lease is only, or not this lease, this agreement is only 15 days, they can throw a rent sign in the yard right now. If it's 45 days, 15 days into it, then they can put a for rent sign on the property, place electronic lock box on property containing keys necessary to obtain full access. So this is kind of the same thing that this access or showing is the same kind of thing that's in our lease. Problem still becomes is what the tenant considers reasonable. I wish they would have some type of language in here for leases to say the tenant will agree within 24-hour notice or something like that. Because I've had some hostile tenants that have refused all showings. Other terms, once again, be careful what you write here. Be careful what you write here because it becomes part of this agreement. What I like about it's only 2 lines, so you can't write that much. Seller signs it, buyer signs it, becomes part of the contract. That's really it to this. I mean, this is a short, simple, sweet agreement. I once again would use to help to do the walkthrough sheet. That's form 1100 on the VAR forms, not the NVAR forms. And now when you have zip forms, because you're a realtor, VAR forms are free, so you should have those in your library. If not, I mean, if they're not in your zip forms, call them, they'll get them for you. If you need them in a pinch, you can go to I think it's Virginia Realtors. They changed the name. It used to be VAR.com, but I think it's Virginia Realtors. Log in with your NERDS number, and you have access to all the forms there. Anybody got any questions? It's pretty easy.
So what is the point of this form? Is it like if your seller his new house isn't ready, so you need to use this form. Is that it?
Yep, absolutely. Yeah, this is saying, hey, the seller wants to hang out in the house just for a couple more days.
I see. Okay. All
And,
right.
and or they say, listen, the moving truck is broken down and I can't get it for 2 more days. Or there's extenuating circumstances. Or you know what, I've got everything. All my glass china is being moved out, and the special movers aren't going to be here. Or you know what, I've seen them say, listen, I don't mind selling to you, but my kid graduates in June 15th. And we're going to close on the 10th, and I just want to hang out here until my kid graduates because I don't want him to live in a hotel while we're doing this.
Mark, I have a question.
Uh-huh.
How long do you typically, and I came in late on this, but how long can this agreement be made for? Can it be
200 years. You can
how
do it
long?
you can do it as long as you want. There's no this form is only good for 10 days, 15 days, 20 days. And I'm glad you came in late so I can tell everybody again, I do not like these forms because it is not it's not a lease. There's a lot of things that could go wrong with them. I mean, do we use them? Yes. But it's kind of like, if somebody gives me a Diet Pepsi, I'm gonna take a sip of it, make a face, and I'm really thirsty. I might take
Right.
2 sips of it.
Right.
But it's not my choice. I mean, but there's a form out here for it. I mean, they made it to use, but there's just so many problems. Now, if it's going to be 2 days, is it worth drawing a full-blown lease? I don't know. But if the house catches on fire, you wish you would have.
Yeah.
Yeah, I mean, this is where you sit down and listen. I understand. Buyers want to buy, sellers want to sell, and agents want to get deals closed. And this form works. I mean, it's pretty simple. But if you don't follow, it's like the same thing too. I'm sure a lot of people don't even look at the insurance requirements. So if you got the seller that's going to stay there, hey, hey, look, run this by your insurance agent, see what this says. Because we want them to have insurance. Yeah, it might cost them, I don't know, 20, 30 bucks. I mean, renter's insurance is cheap, but it's better than the alternative. Don't see a lot of these, but I can tell you, here's what's going to happen. If we start stacking closings like we're kind of getting or we're doing, so the buyers got to close their house in Florida before they can close a house in Georgia to close this house in North Carolina to close my house. And we got to sell this one so the seller, he can go up to New York. We'll get things stacked up, and things might get backed up a day or two. So I think we'll see more of these, but it's really important. Like I said, the form is very simple. I mean, a lot of people just say, how much does it cost me to stay a day? Form, but there's more of that. What else? Everybody sleeping? Katie, you good?
I'm good.
Okay. Joy?
I am good.
How about
I don't either. I really don't like the whole idea of that post-settlement occupancy. I really don't. I hope I never have to use it.
well, go ahead.
Let me ask you. So, because for both the pre and the post settlement occupancies, you're saying maybe a rental agreement is better, but does the rental agreement then become part of the contract, or is it totally?
No. If you do a lease, that's a totally separate transaction. I mean, because this one here, if you read it, it says in consideration mutual terms, well, this thing becomes part of the contract. So this actually becomes part of the sale agreement, so it's enforceable through the sale agreement. The lease is not part of this agreement. But I mean, yeah, to me, it's a Diet Coke. Everybody's watching out there.
Right.
If anybody out there watching Diet Coke, I'm gonna offend you. Well, good. That's not too bad. I mean, it's only 10:23, and I've only offended somebody with just a Coke. But I mean, it has a purpose, you know, and 99% of the time it works out just fine, you know. But if you get somebody just doesn't want to leave, now let's throw this, say, cool, all right, Mr. Buyer, you can stand there, but I want to start moving my stuff in. Then what do we do? And you start getting at other terms. Then you start getting scary down there, because now, you know, then it becomes really really weird. Hey, you know, and it might be because the buyer's got, you know, stuff coming from a truck from Georgia, and he's got to get it off. You know, so I mean, that the cool thing about our business is every day is different. I mean, I couldn't work at Chevrolet Motor Company and just put tires on a vehicle, or something that's very repetitious, very repetitious. I mean, when our business, I mean, everything is different. We've got emotions with our clients. We've got our emotions. We've got everything going on in the world, and our job is to herd the cats, make sure all the cats don't get away. So, anybody else? All right, cool. I don't know who iPhone is and Pixlar. They're hiding. Punch it down. I don't know if Zoom's got the ability to do that. So, all right, well, cool. Hey, look, I appreciate it. I'm going to do our sales meeting tomorrow. I've got some stuff to get through that. So hopefully we'll get some more people in there, and you guys stay plugging. I'm here at the office. If you need something, call me. Okay.
Thank you,
All right.
Mark.
All right. Bye bye.
Have a good
Thanks.
day.
Bye.